So with that information, I'm gonna pass back over to Dan here. He's going to talk to us a little bit more about what the penalties look like for a breach before we go into some actual examples. Dan?
Hey, Jason, thank you very much. Appreciate it. I'm going to talk a little bit about the penalty process for a breach of HIPAA violation. And this goes more than just a security breach. Let's assume HIPAA requires that all covered entities put on certain privacy requirements as well as certain security requirements. And if there's a breach or non-compliance by a covered entity, a healthcare provider, of any of the privacy or security regulations, you're exposed to some risk. There are two types of risks that HIPAA will impose upon folks. I get all the time, and somebody will call me up all the time and said, the hospital released Ma's, told my pa about my Ma's healthcare condition, and I'm going to sue the hospital because they breached HIPAA. And I said, well, they may have really messed up HIPAA for you, but there's no private right of action of HIPAA. Basically, that means a individual can't bring a lawsuit against a hospital or a physician for violating HIPAA. The only persons who can enforce a HIPAA violation are the Office of Civil Rights of the Department of Health and Human Services, the Health and Human Services itself, and perhaps the State Attorney General. So if you do feel like you've been violated by HIPAA, your only remedy is to go ahead and file a complaint with the government. In essence, it's interesting. There is some new law being made out there that says it's kind of negligence for a physician's office to let the cat out of the bag with regard to your protected health information by not following HIPAA, and you may be able to get your physician or hospital on a negligence claim, quite apart from violating HIPAA. You can say, well, they were negligent because HIPAA set the standard at X. They were below the standard, so I'm going to go after them for negligence. But that's something else to talk about one another day. Let's assume that you're there and you're a healthcare provider and you violate HIPAA. You do anything that HIPAA requires or you don't do the things HIPAA requires. And one thing that could be, let's say you did not do a risk assessment for your privacy or security rules. You adopted regs, but you just never did that risk assessment. Believe it or not, that fact alone, failure to do a risk assessment at the beginning, that is a violation of a required regulation of HIPAA. As a consequence, if you're ever investigated, you will be in breach and you will be liable for two types of penalties. There are two types of penalties we'll talk about. One are civil monetary penalties, CMPs. A civil monetary penalty is just what it says. It's a civil penalty. It's a fine. You got to pay cash, you write a check, and you're done. The other types of penalties are criminal penalties. With a criminal penalty, not only must you write a check, but you could also lose your freedom. You could go to jail. So we need to keep those two different types of penalties in different buckets. We're going to talk first about the civil penalty, write a check only, and then we'll talk about the criminal penalties. That's when you go to jail. So what are the civil monetary penalties? Well, there are four categories of civil monetary penalties, and they kind of increase in your culpability and increase in the amount you got to pay. We're going to look at this first one here. If you do not know about a violation and you violate it, it will cost you between $100,000 and $50,000 per occurrence. Let's break that down. So if you do not know about a violation, well, this particular penalty provision only relates to individuals. So that's you and your individual case. If you did not know about the violation, you can still get fined. Well, what does it mean you didn't know? Does that mean that you just never heard of HIPAA before? No, unfortunately, that's not what it means at all. It's pretty clear that when we talk about knowing, at least for the criminal liability, it requires not that you didn't know about HIPAA. It just means that you didn't know it was a violation at the time. So what does that mean? That basically means is your failure to perform the risk assessment at the beginning, that failure in and of itself is a knowing violation. I mean, you actually knew that you did the action, or you didn't do the action. I know that I did not do a risk assessment. That alone, in and of itself, is enough to get you some culpability under HIPAA. So just because you don't know about the need to do a risk assessment does not excuse you, at least here, from any type of culpability. Oh, wow. And then what else does it say? It's going to cost between $100,000 and $50,000 per occurrence. Well, what's per occurrence? Does that mean every time I didn't do a risk assessment? Well, no. What it really says is, and while there's such variability in the amount, it says it's very clear that if you do a violation of HIPAA, and it's a continuing violation, I should have done a risk assessment the first day, and I didn't do it, and here it is a year later, and I still haven't done it. Well, that's a continuing violation of HIPAA. And what does it mean to have $100 per occurrence? Well, the rules tell us that per occurrence means every single day during which the continuing violation occurs. Oh my gosh, that means in 1 year you've done 365 separate violations of HIPAA just because you didn't do a risk assessment at the beginning. Wow, now you've got some real money. Now you're talking 365 violations times 100, up to $50,000, or actually, up to $50,000. So how come there's this big, huge range between $100,000 and $50,000 per day? And the rules give us some kind of factors that the government will think about. They'll think about how many individuals were affected, the time period, the nature of the harm, if there was any harm, whether it resulted in financial harm, somebody lost their job because of your HIPAA violation, whether it resulted in individual's reputation harm, your patient, was made fun of because they had a particular disease and they couldn't get a job, let's say. Whether there was physical harm, oh my gosh, maybe your inability to keep the information secure meant that, secure meant that you, let's say you failed to keep the information secure, and a doctor down the street said, I got to find your information, and lo and behold, it wasn't there, it was gone or inaccessible. And then the patient had an adverse reaction because the doctor couldn't get the information. Well, that's physical harm, and if your breaches cause activity that bring physical harm or financial harm, then that's going to be more than $100 per occurrence. And then the last thing we'll talk about here is how come, we'll talk about that in a minute, but ways to mitigate. But now you can see, even though we have one slide, it's only got 12 words on it, it kind of bristles with all types of legal meaning, and we have to understand what it means to have a violation, what it means per occurrence, why the range is that way, and what it means to know. So that's the first of 4 categories. The next category is if you're an entity and you have a violation due to reasonable cause, you can expect to pay between $1,000 and $50,000 per occurrence. Well, what is reasonable cause? Well, if you have a violation due to reasonable cause, which is defined to mean that you knew or should have known that it was a violation. I mean, it wasn't willful, but you should have known that the activity or your lack of activity would cause a violation of HIPAA. So you can see where we got a little bit higher limits there. The next category is a violation caused by willful neglect. That is corrected, and that's going to cost between $10,000 to $50,000 per occurrence. What's willful neglect? Well, willful neglect means the conscious or intentional failure, or most important, reckless indifference to the obligation to comply. So let's say, let's say you attend a seminar about HIPAA, and people at the seminar kind of indicate that, hey, you need to have a risk assessment, and you say, well, I'm not going to do it because it's just a pain. Well, let's talk about that. If there was a breach and someone could prove that you actually attended a seminar or webinar where the requirement to have a risk assessment was discussed, well, then you knew about it and you decided for whatever reason not to do it. So I'm not dissuading you from attending webinars, but I am just suggesting that you keep these legal obligations that you have in mind as you move about your HIPAA compliance activity. And you can tell, if you have a willful neglect that you don't correct, it's going to cost you some bucks. And if you look at the next slide over, you have a willful violation due to willful neglect that you don't correct. Oh my gosh, you knew you shouldn't have been doing it, and for whatever reason, when you found out about it, you said, "Oh, I guess I could correct it, but I really don't want to. I don't want to do that." Well, in that case, you have even greater monetary liability, and you have, so this is the next slide. Each category has a maximum penalty of $1.5 million in a year. What about the criminal activity? We'll talk about that now. And these are fines for individuals, and it's interesting if you have criminal activity. Not only can individuals be held liable, but also institutions and entities. But let's just say that you have a physician practice. The physician practice, so they're the ones who are the criminals, not me. I'm just a doctor who owns it. Well, the government will likely and can likely go against the officers and directors of the entity personally on these criminal fines. One of the criminal fines, now we're talking not only about writing a check, but also possibly going to jail. That's if you knowingly obtain or disclose protected health information. That means basically you knew that you were getting your hands on PHI and disclosing it in a method that is violative of HIPAA. The next one is if you conduct if you conduct an activity involving protected health information under false pretenses. That's basically calling up someone saying, "I'm an insurance agent, I need your PHI," and you basically get all their protected health information, and then you sell it or otherwise improperly use it. That's a pretty hefty fine, $100,000 plus 5 years in prison. That's not continuing, that's just kind of $100,000 in prison time. And the biggest and the worst and the most egregious thing that could be done is if you intend to sell PHI for financial gain or harm, and that will get you $250,000 penalty plus 10 years in prison. These, again, are brought by the state as a crime against you. The worst you can possibly do is like break into someone's hospital's medical record system and then sell the information on the open market for whatever you can get. That's the key. That's the very worst activity under HIPAA, and the type of activity that will get you into the most trouble. And think about for a minute, let's assume for a minute after listening to my talk that, wait a minute, I've gone to work every day, I've done everything I thought I was supposed to do, and now I'm being told I could write a check for a lot of money. There are, before you get all, too scared about it, there is a provision in the law that says, hey, there's ways to mitigate these damages. We don't necessarily have to go to the extreme of writing a huge check, even for a violation. And the government will look at a range of activities and facts that will mitigate your exposure under HIPAA. For example, if it can be proved that you had a violation, this is a civil monetary violation, not the criminal. Criminal is a different thing. But, they say, oh, you didn't do a risk assessment, and we came by and did an audit, and you don't have it. And you said, well, nobody's been harmed, and you can prove that it wasn't due to willful neglect. I just didn't know. I thought I got some bad information. And if you can show that you corrected the failure within 30 days of your becoming aware of the failure, you kind of get off pretty much free. So the rule there is, wait a minute, I didn't know that I had this problem. I probably should have known that I had a problem. It's a civil monetary penalty. There wasn't really any harm. It's just a few people in my organization. It's a small organization. And once I found out that I was not in compliance, I took immediate steps to correct it. If you can show all those facts to an investigator now or later, whenever it shows up, that yeah, back for in 2013 we didn't do the risk assessment, but I found out I should have done it, and within 30 days we actually had one accomplished. That should probably go very far in mitigating, if not absolutely extinguishing, some of your civil monetary penalty, depending on a bunch of other facts. So that kind of gives you an opportunity to think about what some of the risks are in your failure to adopt a HIPAA compliance plan and have it be vibrant and living in your practice. Jason, you've got some examples?